Hi, everyone. Thanks so much for joining us here for another one of our webinars. I'm super excited about this one. This is the residual risk of residual criminal proceeds. And it's a topic that was born out of just a number of scenarios and calls I've received and my lawyer friends have received over the last while that really have to do with the balance of civil and criminal when it comes to money laundering. You know, if you find out or you suspect that somebody's laundered money, and what do you do with it? And if the person served their time and seemed to have made restitution, when can you start banking them again? And is their money forever tainted? There are issues that just seem to arise that where I think Jerry said it best the other day, where it's like there's snow has fallen and there are very few footprints in it. And so I think it's a fun topic to explore, and I'll tell you about our speakers in a second, who are the perfect folks to be talking to us about it. We're going to walk through things this way. We're going to talk a little bit about, as I have, about what the motivation for the topic was, and then next we're going to talk about the offense of money laundering. And Jerry's going to walk you through both the U.S. approach and the Canadian approach, just so you can compare, contrast, and break those down a little bit in terms of what's required from a criminal perspective. We're going to talk about recklessness, which is a hot topic in any event, having been a recent change to the criminal code, and sort of where that touches on the regulatory side of things. And then we're going to dig deep into what are the implications for regulated entities. So as a bank, as a credit union, as a securities dealer, as a dealer in virtual currency, what does this mean? This balance between civil and criminal in terms of money laundering. We have three scenarios that we're going to walk through to make that a little more concrete. We're going to talk about Quadriga, which has been in the press a fair bit, and specifically around CIBC's freezing of their funds at one point during the scenario. We're going to talk about a hypothetical scenario involving lending, and then laundering following laundering, and then a civil or criminal resolution of that offense, and what impact does that have on your ability to continue doing business with a client and touching their funds in the end of the day. And then we have a Q&A section that we'll walk through. So I do want to spend a couple seconds talking about our speakers. I'm going to start with Bruce. I'm super excited to have him here. He's a former prosecutor and a regulatory compliance expert, dealt with competition, securities, tax, anti-money laundering, allegations of fraud, breach of trust, involved in inquests. Bruce and I have worked together now for I think about a decade on matters related to FINTRAC, where there are penalties or threatened penalties or examinations. And so it's been wonderful working with him and his foundational knowledge in regulations and how to protect organizations from these sort of threats. He's been recognized as one of in Canada's best lawyers since 2013, Lexpert's leading practitioners. Importantly, he's a decent golfer, and a Paul Harris there.
Well, thank you.
Rotary, which is a really big deal. I would invite you to have a look at his website. If you just Google Bruce McMeekin, his website has an ongoing series of articles on AML that are just fantastic. There's one on recklessness, and just a great series that breaks down and explains in detail what these concepts mean and how they apply. And secondly, so thanks for being here, Bruce.
Thanks for having me.
And then Jerry, we've been having a ton of fun working and speaking together. He's a certified specialist in criminal law and has argued in front of all levels of court in Ontario and before some administrative tribunals. He's got some fun war stories as Crown Counsel, where he received specialized training in search and seizure law, and he's been very active in the anti-money laundering community in Canada. It's been incredible, his contributions. He actually got his CAMS in 2015. And the CFCS designation from the Association of Certified Financial Crime Specialists in 2016. And he's really been a thought leader in this space, having been on the side of prosecution of money laundering and then in advising financial institutions subsequently. So really super excited to have both of you here and have your perspectives. Thanks for joining, Jerry, also.
Thanks.
All right. Jerry's going to kick it off with talking to us about the U.S. approach.
Thanks, Matt. I do need to do the standard lawyer caveat, which Bruce will probably agree applies to him, and that is that, none of this is legal advice, and anything that I'm talking about today is sort of in the realm of thought about the area and discussion, and that it's not intended and it shouldn't be taken as legal advice, and it's in particular related to me. It's given in relation to my current practice as a regulatory defense lawyer and advisory lawyer, and that's the context in which I'm giving this. But so I wanted to start out by just setting the groundwork by mentioning in passing the U.S. state of affairs in comparison to Canada. Many people apply the classic, placement, layering, and integration model and think of money laundering as someone's hiding the origins of their money. To a large degree, the U.S. legislation requires that, but Canada doesn't, in my view, in my opinion. So the U.S. law requires intent and knowledge. So you have to intend to do something that's typically in the statute related to the concealment of the origin of the funds, and you have to have knowledge about it. There are some additions, and they include attempts in which you're not actually accomplishing the offense, but you're trying to do it, which is a very high level of subjective fault. And then conspiracies, which would be agreements, even though there may not be an actual completion of a transaction. And then there are sting operations, and this will make some more sense when I talk about the Canadian law as it relates to knowledge and belief. But in the US, there's a specific statutory carved out offense related to sting operations. And in those circumstances, you don't have to actually be dealing with proceeds of crime. It's different than Canada, as we'll see. Next slide, please.
Of course.
So this is the offense as it is as of June 2019 in Canada. I'll break it down more as we move forward, but what I really want to emphasize is that in the fifth line there, you'll see or being reckless as to whether. And that is the major addition that was included in the substantive criminal offense in Canada as of June 2019. Now, recklessness is different than what we were just talking about with the US, with knowledge and intent. And so if we could go to the next slide. If you break down what we just looked at into its constituent elements, you can look at the first bunch of words as a series of things that people will do. So you can use, transfer, possession, transport, transmission, alter, dispose of, but it gets broader and broader as the wording continues. So it becomes any property or any proceeds of property, and it's also deals with, it includes dealing with it in any manner and by any means. So all the other wording specifies specific ways that you can conduct in offside activity, but then it gets broader and it says by any means, in any manner. And then very significantly, we move on from the actions associated with money laundering to the mental requirement. And I break it down into two parts because one is about the intent, and you'll recall the US requires intent. And then the second part is related to the state of mind of the person who may or may not have that intent. Within the intent area in section 462.31, there are really two modalities or two options. One is concealment. So you would have the intent to conceal. The second is the intent to convert. And although they're both included there, they're very different things. And you don't have to prove both if you're a prosecutor. So if it is established that somebody actually commits the classic type of money laundering that we all think about as concealing the source of the proceeds, that makes sense to everybody. But not a lot of thought is going into the second way that it can be committed, which is through conversion. And conversion at law in Canada and in the common law is any sort of transaction. There doesn't have to be anything sinister about a conversion. And so this is the bigger danger for reporting entities. This is the area where they're regularly transacting, and that starts to fill in the elements required for somebody to eventually point and say, that actually amounts to money laundering. But of course, you can't have it with simply an intent to convert, because everybody intends to convert when they deposit funds or do a funds conversion. When you get to the mental requirement for what you know, the mental state, there's 3 ways now. As I pointed out, recklessness has been added, but if you know the funds or the proceeds, any property, comes from an indictable offense, and I'll mention what those offenses are in a moment. Everyone can understand that, and everyone's used to thinking of it. Well, if you know it's dirty money, clearly. But then Canadian law has added believing in the late 90s. It wasn't entirely necessary because of a Supreme Court case called Dinar, in which somebody believed they were dealing with proceeds of crime, although they weren't. It was a sting operation, and Canada doesn't have specific sting operation wording like the States does. So the Supreme Court said, well, although the Act says you had to just know, because you were trying to commit the offense, you were attempting to commit it. And so this is, I'll be mentioning the attempt provision later, but believing then became actually inserted into the statutory wording. So then we had knowing or believing. But then in 2019, this entirely additional mental state was added, or being reckless as to whether. And this broadens significantly, in my view, the scope of not only regulatory compliance and reporting, for example, to FinTrack under our PCML TFA, but the substantive substructure, the entire groundwork on which AML is premised in Canada, has now been significantly expanded. And then if you move through the elements, you get to obtained or derived, directly or indirectly, very broad as a result of an indictable offense. Now, when I say indictable offense, this is something I wanted to make sure I made clear. It actually says designated offenses that are indictable because they're in a federal act that is not carved out by way of a regulation. So there are some regulations that you wouldn't think of, some acts you wouldn't think of, like the Seeds Act and things related to our agriculture. Those are carved out from the predicate offenses that are set out there, but otherwise it's any federal act that has an offense that is indictable can be a predicate offense, not just criminal code offenses. So income tax, environmental, those sorts of things. Next slide, please. And so this is sort of the framework that we're working in now in terms of the mental state. Knowledge is probably the most narrow. Belief can be broader, and it doesn't even require an actual predicate offense involving real proceeds. And then recklessness now it's never been interpreted or really looked at hard by the courts. Next slide, please. So I break it out into a chart like this. You'll recall I was talking about conversion as opposed to concealment. So this is laying out the easiest way, if I can put it that way, for a prosecutor to set out to prove the elements. Frame it in conversion. No need to prove the concealment aspect, the intent to conceal, just have an intent to convert. So in that scenario, when you're dealing with the element requiring knowledge, you have to have a predicate offense, because a knowledge is a true belief. You have to be right in order to know something. And so you have to be right that it's proceeds. If you're wrong about it being proceeds, then it turns out you're attempting. You're still guilty, but it's a different form of mental element. For belief, again, you don't need a predicate crime, and that was made clear in Dinar when the funds were a sting operation. The court said, well, they actually can't be convicted of knowledge. They had to resort to an attempt in order to find that the offense was made out. But now that belief is added, you can have this because you believe you're committing the crime without an actual predicate offense. Now, moving across the board here to recklessness, it's arguable, and it's my current view, that there hasn't been a predicate crime requirement in Canada ever since Dynar or since belief was added, and recklessness certainly wouldn't inject a new requirement. If you're reckless, in my view, it does bring in behavior that involves recklessness about proceeds of crime as to whether it is proceeds of crime, not recklessness with proceeds of actual crime. And so it covers where there is no predicate offense. There's a strong argument for that. Again, it's not been interpreted by the courts.
So is that, do you mind if I step in just for a second? Because I want to understand that a little better. So are the two practical implications of that in the case of a sting operation, like a Tajani sort of scenario, or in a case where it's not an indictable offense in Canada? So let's say it's an indictable offense in China, but not an indictable offense here. Are those the two sorts of scenarios that would be contemplated by laundering without the proceeds of crime?
Well, once you have a knowledge or a belief, it wouldn't matter because recklessness would be covered off because you're already in the game, so to speak. When you're dealing with foreign crimes, it gets much more complicated because the recklessness would have to be reckless as to whether it is a Canadian offense, as set out in the predicate offenses. Very often, conduct that is foreign can come within a domestic crime. If you're in Canada and your fraud is very broad, for example, someone may have a very specific statutory offense in another country that it would appear to be made out, or that's really the thinking at the time. But if you look at it from another lens, someone may say, well, you're just actually being dishonest and someone's put to their detriment or exposed to that risks, then that qualifies as a fraud. If it's fraud and it can be elected indictably, it's an indictable offense. Therefore, that brings you back within committing a predicate offense in Canada, regardless of what the person is charged with, say, the other end of a transnational crime organization or at the other end of it. So Canada's statute is broad, and the scope of the offenses don't have to be articulated in a way that takes into account the wording of a foreign statute, as long as there's a Canadian offense in a federal act that would qualify, in my view.
Thank you.
Next slide, please. Before we move on to recklessness, and Bruce is going to take over largely, it's important to know that in the Canadian Criminal Code, the offense can go quite a bit further, and there's other ways to prove it. And these are not things that are outside the actual offense. There are other ways of proving the offense. So money laundering, although it's contained within 462.31, is also can be proven through an attempt, as I've discussed. It can be proven through any of the party provisions. So if you're helping somebody to do something and you qualify for the mens rea or the mental fault requirement associated with that action, you could be convicted of being a party to a money laundering offense. Additionally, if you counsel somebody to do something, you could, in the right scenario, be prosecuted and be guilty of the money laundering offense. And we also have conspiracy provisions in Canada, as well as aiding and abetting. So even though you're not the person doing the conversion or the concealment, by helping somebody, you can be a party to the offense. And so there are a number of additional layers to ways that somebody could be involved in money laundering, and it certainly involves, it certainly is worth some thinking about that.
Very good. Should we move on to Bruce's section?
Yes, thanks.
Okay, so I actually, Matt, you don't have to go back, but just before I start into this slide, I just want to add a few things to what Jerry said about the impact of recklessness, and begin by saying that Jerry and I are in agreement about the fault requirements for the prohibition. And that view isn't universally held, and that there's no recent case that looks at the prohibition as it stands now and has considered the precise question of what are the requirements that fall on the Crown when it comes to having to prove a predicate offense. But having said that, with reference to the cases that Jerry mentioned, I think we're in the right, if I can put it that way. There is recent case law that is considered recklessness and has equated it to heightened suspicion in this sense. It is said that you can't be conscious of risk. I'm speaking within the context of recklessness, of course. Consciousness, you can't be conscious of risk that you ignore unless you have a heightened suspicion that to apply that to money laundering, unless you have a heightened suspicion that what you're dealing with are the proceeds of crime. And that theme is going to run through just about everything that I'm going to have to say in the next few minutes about the application of recklessness to regulated and how it affects regulated entities. So with that, referring to slide 11, a couple of things. First, regulated entities, of course, are created by something called the Proceeds of Crime legislation. It creates the concept of a regulated entity, and in so doing, it clothes it with a number of responsibilities, or in law, statutory duties of care that require a number of things from regulated entities, including written policies and procedures, training, and the whole 9 yards. The Proceeds of Crime legislation, in effect, places regulated entities as being the ears and eyes of the federal government at the front lines of transactions, in that they are required to detect and in certain categories automatically report transactions to FinTrack, or in some cases, of course, reporting suspicious transactions. And although the Proceeds of Crime legislation creates substantial liability for regulated entities in the event that they fall offside the statutory duties of care, for example, failing to report a suspicious transaction, there is nothing in the Proceeds of Crime legislation that prohibits money laundering. And that, as Jerry has pointed out, is within the ambit of the criminal law and the money laundering prohibition. Following the requirements of the Proceeds of Crime legislation may minimize the risk of a regulated entity exposing itself to the money laundering prohibition, but it does not insulate the regulated entity from criminal liability. And I'll explain how that can be the case in the next few slides. Suffice it to say, as prelude, I think that the smart money bet on regulated entities avoiding an allegation of money laundering will be placed on those that, because of their business operations, and the requirement that they must detect risk, in other words, suspicious transactions in their dealings. I think the smart money for avoiding liability will be on those regulated entities that embrace a policy committed to preventing money laundering and implementing systems to minimize the entity's exposure.
So Bruce, I did just like as a recap of that point that what you're saying is that you could follow the AML legislation to the letter, that the Proceeds of Crime, Money Laundering, Terrorist Financing Act to the letter as a reporting entity, and still end up afoul of the criminal code.
Absolutely. So let's talk about what I would describe being the heightened criminal exposure of regulated entities. It's heightened because, as I said, because of the services that regulated entities offer, and also because of the procedures they're intended, that they are required to implement to detect and report transactions that are reasonably suspicious. Reasonable suspiciousness in the scheme of mere suspicion all the way up to certainty is a relatively low threshold, in that it simply means a suspicion objectively viewed or discerned that quantifies the suspicion as being reasonable. It's an objective measurement. And because it is a suspicion, it equates to possibility. And the analysis permits a conclusion to the contrary, that what I have before me is not a reasonably suspicious transaction, and therefore something that I don't have to report. Because regulated entities are required to detect and report suspicious transactions, however, I'm going to venture, I don't think it's even a guess. I think it's a lot more than that. Then in so doing, regulated entities are going to encounter transactions that surpass the threshold of suspicious of reasonable suspicion, something that becomes more heightened, a heightened suspicion. And that, as I've indicated, is the potential trigger for the staff of regulated entities, and following the rules of criminal liability that I'll summarize quickly in another slide, the organization itself to an allegation of money laundering contrary to the prohibition. Can we go to the next slide, please, Matt? Okay, so this slide originates from a couple of conversations that Matt and I have had recently about regulated entities that have found out information about the past of current clients or ongoing activities of current clients, and it's raised the question, that this whole presentation is directed to, and what do you do in that eventuality? And the three bullets that I've got listed are the three that seem to appear most frequently in discussion with regulated entities as responses. One is freezing funds, and Quadriga, which we will come to shortly at the end of the presentation by way of an example, it is an example of that. The CIBC froze the funds held it in its accounts, and applied in law for the relief or remedy called interpleader, which basically permitted it to pay the funds held in its accounts into an accountant at the Superior Court of Justice to hold, I guess, in a sense, in trust until the claimants to the money held in the CIBC accounts sorted out ownership. So it took the CIBC right out of the equation, right out of the litigation. So in that sense, it was good. But on the other hand, it left the bank exposed to claims from the owners of the funds that they had been damaged by the freezing of the funds. And that was one of the outstanding issues that was left unaddressed by Justice Haney in 2018 when he released his decision. And I frankly myself don't know if CIBC has been sued by the parties for damages. But the reason why I'm raising it here is that it's an illustration of the risk that a regulated entity can encounter when trying to do the right thing. Another is, well, we'll just return the funds to the client. That in itself may be a risk because arguably it could be seen as a conversion or a layering, and therefore money laundering in itself. So you could be digging the hole not only on the civil side by freezing, but on the criminal side by deciding to willy-nilly just return the money to the client. The third is police involvement. All of us, I think, have been brought up to believe, and rightly so, that the police are there to help us, but they're also there to investigate criminal offenses. And in bringing in the police without a very clear understanding of the transaction that is problematic, the regulated entity could be opening itself up to investigation by the police and exposing it to criminal liability. Can I have the next slide, please? So how do you address that risk? And this is not meant to be an exclusive list. It's things, though, that I think would rank at the top of how you should prepare for the risk, the heightened risk. The first is something that would be above the policies and procedures that we see every day as required by the proceeds of crime legislation, and rather something much broader in some aspects of the criminal law, namely minimizing the risk of very large corporations to allegations of bribery of foreign officials or officials abroad. Many organizations have brought in the concept of a compliance policy. In other words, that recognizes the risk and creates systems intended to transparently monitor transactions and identify irregularities that should be investigated more closely. In other words, it's a very intense form of self-auditing. I see the concept of a compliance policy in that vein being something that would be attractive here. And it's something that could include written policies and procedures for proceeds of crime, or something that could be operate in parallel too.
I'm just trying to picture that, Bruce. So if there's a few places where I could see that working into a program, right? Where, you explain, here is what the minimum bar is for reasonable grounds to suspect, right? That should be in everybody's program policies and procedures and their training program, right? And they should be training their people on that thing. Is it the next step to say, well, listen, if you get beyond that, if you get further up that or further across that continuum, here's the things you need to do that are supplemental to just filing a report to FinTrack. Here's who it needs to be escalated to and such.
Yeah, I mean, as an easy example, if somebody was regularly coming into a credit union branch to complete repetitiously of the same type of transaction, the repetition may, and may escalate or rise to the level of reasonable suspicion. But over a certain period of time, the repetition is going to go, in my mind, well beyond the idea of reasonable suspicion. It's going to get right up there with heightened suspicion. It's that type of situation that I'm talking about. The help with heightened suspicions, because it's not something that I would expect everyday regulated entities to have their arms around and understanding. But unfortunately, we have tons of retired police officers. We have tons of retired Crown attorneys who can make themselves available in identifying the indicators, the signals that one might want to look at when differentiating between what is reasonable suspicion and what is a heightened suspicion. And just stop there for a moment. The distinction is just not an elevation. It's taking something that reasonably looked at, a person might come to the conclusion and say, yes, that's suspicion. When you get into heightened suspicion, for want of a better way of putting it, you're talking about something that is hitting you right in the gut. There is something wrong with this. It goes beyond the possibility that this transaction is, could be possibly suspicious. And here are the indicators in my mind that make it that way and make us have to red flag it as something that we have to look at more closely.
Since I'm an accountant, I love reducing things to numbers, and without royalty, I've been punking Jerry's approach, which is this percentage certainty as a shorthand for this continuum of certainty. And so I think it was a Calgary Police Service case, Jerry, where the decision described how he said, listen, I think reasonable grounds to suspect is something more than 11% certain, and he worked it along the continuum that way. Is there a number we could apply to this sort of scenario of reasonable grounds to suspect and heightened suspicion?
There's no number, is the short answer. That case is unique, although I've made reference to it in the past and also pointed out its uniqueness. But it is an interesting attempt to try to put a number on it, because we would all love to have a line.
Yeah.
We'd all love to be able to, well, in some sense, get back to tick box approach. And if you could have them and know the answer, but unfortunately, it's a matter of judgment and perhaps a mindset that's receptive to information.
Okay, fair enough. So I won't bust out my abacus then. Fair enough.
It's unfortunate that we don't have a number, but nothing mathematical would work. When someone's at the counter and somebody's coming in repeatedly with a satchel full of money with white powder on it, it might get heightened suspicion. One would think that mathematically that would get you there.
Fair enough.
Okay, so the second point is training, and by that I mean what is the expectation of staff when their suspicion is heightened. And if you don't, and I see this being pretty basic, because if you don't train staff on the notion of heightened suspicion within the context of your compliance policy, you're leaving them exposed. They're the ones who are actually doing the transaction. And they are left exposed personally to an allegation of money laundering. And under the right circumstances, again, I'll describe, when it comes to the organization, exposing the organization as well to an allegation. So there also has to be, a system by which when a staff member involved in a transaction, when his or her heightened suspicion is triggered, there's a system that kicks the thing upstairs to the right people who are trained under the ambit of a compliance policy to review it and come to a conclusion within the confines, again, of the compliance policy, what is to be done. Is the client told in the vernacular to get lost, or is it that and we report it to the police?
It is a really awkward spot, Bruce. I mean, when it comes down to it, you've got this competing priority of not tipping off the client, right? And so what we're talking, I mean, what it seems like you're talking about is interdiction. That if somebody at the counter gets to the point of heightened suspicion, they shouldn't process the transaction that's in front of them. How do we balance?
Well, that's a really good point, because a lot of police agencies, Matt, would probably prefer to be informed and before the transaction is terminated. And that is because they may very well want the regulated entity to continue within the context of a police investigation. So, good point. And I think I would put it a different way when I'm talking about people reviewing it. That is a factor that would have to be considered. Do we go to the police first? And I can say that I again, I'm going to get into this organizational liability thing in a minute, but that depends on the circumstances, because it really depends, in brief, how deep is the regulated entity into it. Okay, because by going to the police, you may be doing the right thing, but you may be exposing the regulated entities and its shareholders to liability. Okay, like in the case of the shareholders, indirect liability.
And if I could just add a comment that, the tipping off offense in the PCML TFA, it's worth a close look, because it's refusing to transact and having somebody then conclude that you found them suspicious and that you might be reporting them is not the same as the offense that's laid out in the act. And without getting into it further, there is a difference there.
Well, with it, because it ends with that tag, which is with an intent to prejudice an investigation, right? And which is certainly not the, and then our hypothetical scenario, that's not the case. That's not what they were going for.
Right.
Okay, so last bullet, the contract, and when I'm using the word contract loosely here, and it's meant to refer to the documents or the documentation that defines the relationship between the regulated entity and the client. Okay, and in so doing, identifies rights, obligations, etc. of the parties. I'm going to get into in a later slide. I've included it here because if the contractual information does not include provisions that clothe or provide the regulated entity with rights such as freezing funds, returning funds, terminating relationships. It leaves them a little bit hamstrung and in a position where steps that they may take may expose them to civil liability.
I suppose you'd also want, to protect yourself against the potential for consequential business losses that occur because of the freezing.
Yes. Yeah. But you got to balance that, the consequential business losses with the risk of being charged and prosecuted for a criminal offense. And the risk of that to your business, I think, would be horrendous, right?
Yeah, and absolutely. And actually, what's been going through my mind throughout this slide, Bruce, is the whole concept of the risk assessment in the first place, right? If we're talking about a risk assessment that protects us from, financial and reputational risk, just the risk of regulatory compliance isn't enough to consider in that risk assessment. We've got to go that one step further and say,
yeah,
because those risks are far more significant than just a penalty. Which a penalty is inconvenient and frustrating and distracting, but it's nothing like having your name in the paper because you're being charged.
Yes, absolutely. And I think I'm going to come to that point on the next slide, I think, which would be slide 13, right?
Okay. Slide 14. This one, 3 errors to be avoided.
Right. Okay. So the knee-jerk reaction, and I think everybody knows what I'm talking about there. And I'm talking about a situation where the first reaction is to call the police or terminate the client relationship without really knowing all of the circumstances. And it underlines, again, the need for a system within the ambit of a compliance policy that sets out what the response should be to situations of heightened suspicion. And it may require the involvement of the regulated entity's lawyer, because we're talking here generally about things, and the fact situations are never going to be the same. They're all going to be different. And I say you may want to speak to your lawyer. You should have your lawyer involved in all of these, really. I'm not waving the flag for Jerry and I, believe me, but okay. But I mean, you all the regulated entities that we're speaking to today are going to have their own lawyers, and get legal advice before you do anything. The second bullet, the lack of transparency here, and what I'm really talking about is the absence of transparency created by there being an absence of a system within a compliance policy. If you don't have the requirements clearly set out and understood by staff through middle management to the leadership of the organization, then you're going to find yourself in a hole. You're going to find yourself militating towards the knee-jerk reaction what you want to avoid. And the last is deciding against any action absent clear recorded reasons. And in other words, don't kick the can down the road, because eventually, if you do it often enough, there's an elevated risk that it's going to come back and bite you. If you do decide that action isn't required, again, that decision should be made according to the factors set out in a compliance policy, and there should be a written explanation for the way that the decision was made, because you want to be in a position, of course, to protect yourself and explain what happened if there's that need somewhere down the road, which is a risk.
And,
So,
if I could make a comment there, Bruce,
yeah,
I agree completely. And the defensibility is not, there's nothing negative about that, because it's really the accurate recording of what took place for later scrutiny. And, things like exceptions, decisions that override a policy are huge risk areas. And executive, or say a director of a sales team, overriding the decision of somebody who is in compliance would be a massive area for risk to an organization and the individuals. And when Matt was talking about math earlier in terms of reasonable suspicion and can we get there, if you want to think of the words as the math here, if you have a compliance program and it itself is well crafted and reasonable, it's pretty good math that if somebody's violating that policy, there's a significant risk that they're in the reckless zone there. And
Yep.
so that's just a comment.
Matt, can we go back briefly to slide 13?
You're delighted to, yeah.
Okay, so under the first bullet, I just want to I miss doing this, and I should leave with people an understanding of criminal liability for organizations. And this is a topic that you could spend another hour on, talking about the intricacies. It's very complicated, but put it this way: a simple employee who commits a criminal offense on the job has not necessarily exposed the organization to criminal liability. Rather, the organization is exposed only if a senior officer, and I'll come back to talk a little bit about that in a second, a senior officer has had some involvement in the transaction, okay? And that the senior officer has been a party to the offense, okay, to the transaction. Jerry described that earlier, a principal, an aider or an abettor to the transaction. Done something, aiding and abetting, all it means in the case of aiding is you've done something that's contributed. Abetting usually means you've encouraged the transaction. The second is you've directed the transaction despite heightened suspicion that it may be money laundering. And the third is when the senior officer fails to stop the transaction through the exercise of reasonable efforts, knowing or having a heightened suspicion that the transaction is about to occur. And that phrase, senior officer, it's a little bit deceiving, okay, in that it does include, in the definition of the criminal code, the CEO, the CFO, the people you usually expect to be described as being a senior officer of an organization. But it also includes, by way of definition, persons who manage an important aspect of an organization's operations. Now, thinking about that for a moment, that's a terribly broad statement, because for the simple fact that most organizations would consider most of their operations to be important. And for that reason, somebody as low as a construction foreman on a construction site has been found to be a senior officer. But the point is this, that one of the rationales of the system I have talked about is that you want to be able to kick the matter upstairs to a person who is a senior officer, who is in a position to deal with the transaction, which has created the heightened suspicion in a manner that is, what's the word, is consistent with the compliance policy and the system within it to detect and deal with money laundering offenses. And in so doing, you minimize the exposure of the organization, and for that matter, the actual employee who may have been the hands-on person in dealing with the transaction. So with that, can we go to the last slide, Matt? So I think I've already dealt with Quadriga as an example, and the pitfall being that the message being that if you're not prepared for the eventuality of, if you're not prepared to deal with money laundering by clothing yourself with contractual rights, for example, that permit you to freeze funds pending the completion of an example, or pending the completion of a investigation and a court order or another order, for example, a search warrant telling you what to do with the funds, you should. It's a message. Prepare yourself contractually.
Well, and so let's take that example just a little bit further. So let's take the example where that's not the case, where you're just seeing the webinar today and you're like, geez, I wish all my contracts had clauses like that in there. What's available at common law, or are there criminal code provisions that apply to the potential for somebody to freeze an account in the absence of a contractual provision?
I'm not a banking or a commercial guy, but let me put it to you this way: I would feel a lot more comforted if there was something in a contract that provided me with that right. I guess there would be a public policy argument, absent contractual rights, that you should be permitted to freeze an account without civil liability pending the investigation. But what if you're wrong? And we're talking about an investigation that's lasted months, and the client has been damaged by the freezing of the accounts. You got to weigh those considerations, right?
And on that point about the contract versus common law, I think you can't really be forced to perform a contract, as Bruce was saying, read public policy, to commit a criminal act. The problem you're going to get into, though, is the debate later about whether, when the other party says it wasn't proceeds of crime, you just thought it was, and you say, well, it looked to me like it was criminal funds, so I did what I did, without having all that contractual framework that Bruce is talking about. You're exposing yourself to that big fight that could go on for years and cost a lot of money.
And of course, that's the trigger, right? Heightened suspicion, not certainty, but heightened suspicion. So the second scenario, the question, as I understood it, and help me here, Matt, if I'm getting it wrong, was what about a client who has transacted with the regulated entity, and at the time the client becomes a client of the regulated entity. It's not known that he has a criminal past and that he has been prosecuted and convicted, and has paid his dues. It may have even forfeited the amounts that the court quantified as being the proceeds of the crimes that he or she may have committed. What do you do in that type of situation? I mean, you don't have, on the other hand, any heightened suspicion that funds that are being used in transactions between the client and the regulated entity are proceeds of crime. All you have is some idea of the client's past. And I guess my thoughts on this scenario are a little bit more on the preventive as opposed to the reactive side. And that I think you want to attempt to minimize the risk of there being a relationship created between you and a client with a dark past through the rigorous application of know your client provisions, of which people listening to this program, and you, Matt, and I'm sure you too, Jerry, know a lot more about than I do. But why permit yourself to fall into a relationship that may create risk that you don't want? And sorry, go ahead.
No, I suppose, at the core of the issue becomes, once that's, I guess, and the title of the presentation kind of spoke to it, right? Which is this whole idea of residual criminal proceeds, and at what point does residual criminal proceeds become clean? That is to say, if it's evident that somebody was in a business that was fundamentally against the law, and made a bunch of money off of it, and then entered into a settlement agreement, either civilly or criminally, that satisfied the government. They entered into an agreement, but there's money left over. At what point does those proceeds ever become touchable? I guess was the motivation for the idea.
Yep. Well, it's a really tough question, and it's one that I would fall back on in terms of contractual rights. If it became known at a later date that this person had a criminal past, and there was a concern about the residual funds, well, I would be asking myself, what was in the contract between myself and the client that spoke to this possibility? In other words, is there a good faith provision in the contract? Is there a contract that obviates or eliminates, I should say, the relationship? If it becomes evident that the client has been less forthright in identifying his businesses in the past, information provided to induce the regulated entity to contract with the client, I would be asking those types of questions to see if I had an out, because I wouldn't want to stay in the relationship.
Yeah.
Oh,
I'm sorry to cut you off there, Bruce.
So does that answer the question, or?
Yeah, and I guess to just I think to put a really fine point on it, I'd put the proposition to you that if you know that those funds were residual proceeds of crime, despite there being a settlement or having served his time, restitution, and that, like that, the residual criminal proceeds, if you knowingly dealt with them, you could theoretically still be charged with laundering the proceeds of crime as a financial institution. That's really where I'm trying to get to.
I think the answer, and Jerry, pipe in here, I'm not going to say no. Okay, I think it's a possibility. Would the Canadian police be interested in prosecuting somebody who has already been prosecuted, convicted, and forfeited money in the form of proceeds of crime? Would they be interested in continuing a prosecution against that person for laundering the residual? I got to think in my heart the answer to that is no, but it's a possibility, and there's nothing in the prohibition that would say likewise.
It's very complicated, and I got to remind everyone about at this point about my caveat about legal advice. But the
me too.
There is and there is a scenario in which your reporting requirement is one thing under the proceeds of crime PCM LTFA. You got to report things, but if you look to the wording of the provision, if you know that the funds are, let's call it proceeds, and you do something with them for someone, you're committing money laundering whether you're prosecuting or not. You're prosecuted or not. If you believe they are proceeds, you are committing money laundering whether you get charged or not, because you're attempting to do it for someone. They could have clean money, but if you believe it came from crime and you do something with it, you're actually the money launderer there. The other person is not the money launderer. You're believing you're money laundering, and you are.
Yeah.
Then when we add recklessness, this is where the soup gets really messy here, because if it's not proceeds, so you can't know it is, and you don't believe it is, but you've heard news reports of negative news about somebody, and you've read about a settlement, and you've read about charges being withdrawn, and you see this person who you could be a crime figure, some thought, some process has to be put in place to enable you and your employees and your organization to draw a line somewhere and choose to act or not to act, so that you're not behaving quote unquote recklessly. And this is the thing it's new. It's new in Canada, right? This is a couple of years old, and it's not really been tested, and it's dangerous.
That really puts a tidy bow on things. So, just one final proposition that to take that one step further, I'd say that those residual proceeds could never become clean unless they were paid into a court and distributed afterwards.
Well, I'd say this. A court order always insulates a regulated entity from liability, right, Jerry? I mean, I think Jerry's point is an excellent one, in that one of the slides that we had in this presentation was doing the right thing. You want to do the right thing, not because you could be charged, prosecuted, and convicted, although that's a risk. You want to do the right thing because it's the law. Anyway. So we move on to the third point.
Yeah, yeah. I think that the third point is actually we've gone on a fair bit about that one as a consequence of the discussion. I think we've hit the third scenario quite well. So there was just this article here that was kind of a one you could look at to understand a little bit more about Quadriga. I think, Bruce, did you want to say anything about it?
No, other than what I've said about the potential liability of CIBC for freezing the funds. I just reiterate. I have no knowledge about what has happened by way of litigation. It may be that nothing has happened. It just was mentioned as an example of risk.
Very good. Thank you. Listen, gentlemen, I really appreciate both of your perspectives in this session. Really, it's a topic that I haven't seen much about in the press or in the community in Canada, and I think it's going to help expand our knowledge and our approaches to this story. I think at the end of the day, there are two big stories that came out of what you've talked about. It's the expansion of the offense and really the lowering of the bar there on that offense. And then second, you have to have good policies and procedures and contractual language to protect yourselves against these scenarios going forward. Do you want Jerry? Do you have any closing comments before we carry on to Q&A?
Not for me, Matt. I think we've covered the things we wanted to cover.
Great. Well, thanks very much. We'll close it off for today. And again, I appreciate it. Thanks you all for watching.
Thanks, Matt.
Thanks, Matt. Thanks, Bruce.
Thanks, Jerry.